Hello, and thank you for joining today's presentation on ADA compliance. My name is Cheryl Wilhite, and I'm one of the Senior Human Resources Manager here at DECAL, and I will be facilitating today's presentation. Today, we will cover what is ADA, or Americans with Disabilities Act, how does DECAL comply with ADA, what is a reasonable accommodation, who initiates an ADA request, and a supervisor's role as it relates to ADA and the process. But first, we're going to discuss what is ADA. The Americans with Disability Act, ADA, is a civil rights law that prohibits discrimination against individuals with physical or mental impairment that substantially limits one or more major life activities, a person who has a history or record of such an impairment, or a person who is regarded by others as having such an impairment. Now, what do we mean when we say regarded by others? Take, for example, someone who has cancer that's currently in remission. Regarded as means that the person either has an impairment that does not substantially limit a major life activity, or has an impairment that substantially limits a major life activity only as a result of the attitudes of others towards them, or does not have an impairment but is treated by an entity as having an impairment. The Americans with Disabilities Act was signed into law on July 26, 1990 by President George H.W. Bush. The ADA is one of America's most comprehensive pieces of civil rights legislation that prohibits discrimination and guarantees that people with disabilities have the same opportunities as everyone else to participate in the mainstream of American life, to enjoy employment opportunities, to purchase goods and services, and to participate in state and local government programs and services. Title I of the ADA applies to all workplaces and protects employees and applicants in the workplace. And Title II of the ADA calls on state and local governments to ensure that qualified individuals with physical and mental disabilities are afforded equal opportunity to participate in those programs, services, and activities offered by state and local governments. Now, how does DECAL ensure compliance with ADA? ADA is referenced in the DECAL policy manual. It is DECAL's policy to provide equal employment opportunity to applicants and employees with disabilities as covered under the Americans with Disabilities Act. What this means is that a qualified individual with a disability may request a reasonable accommodation at any time during the application process or during employment. Reasonable accommodations are changes made to the work environment or circumstances in which the job is customarily performed that allows an individual with a disability to perform all essential functions of the job. Note, the department is not required to provide an accommodation if doing so would create an undue hardship to the department, or if the accommodation poses a threat to the health or safety of others in the workplace. And we'll go into more detail about undue hardship and also reasonable accommodation and essential functions of the job. DECAL complies with Title I and Title II of ADA, which prohibits discrimination on the basis of disability in the provision of services, activities, programs, or benefits by DECAL. Any individual alleging violations of Title I or Title II may file a complaint through the complaint procedure. Now, we just mentioned reasonable accommodation. What is a reasonable accommodation? A reasonable accommodation is any adjustment or modifications made to a job or work environment to allow an employee with a disability to perform the essential functions of the job, or enjoy equal benefits of employment. The ADA requires reasonable accommodations in three aspects of employment. One, to ensure equal opportunity in the application process. Two, to enable a qualified individual with a disability to perform the essential and underscore essential functions of a job. And three, to provide an employee with a disability to enjoy equal benefits and privileges of employment. Now, there are two ways to initiate an ADA request. First, the employee would need to complete a request for reasonable accommodation form and return it to HR. Again, as we mentioned earlier, reasonable accommodations may be requested for the following purpose: to assist or to complete the employment application process, to perform the essential functions of the job, and again, to have the same benefits and privileges as a non-disabled employee. The employee will submit this request along with a healthcare professional form to their doctor for completion and submission. The next form, this is a sample of requests for reasonable accommodation. Again, here you would check off, or the employee would check off, is it during the application process? Is it to perform the essential functions or to have equivalent benefits as a non-disabled employee? And this is required to further, not only is this request required, but the healthcare form is required to further describe how their condition restricts their ability to accomplish their essential functions. Now, we talked about the request for reasonable accommodation. Here on this, throughout this entire process, the employee is asked to, one, describe the accommodation that they are requesting, and basically to explain how the requested accommodation would be effective. And two, identify any potential resources or suggestions to consider in responding to accommodation requests that must be purchased or acquired. You'll see here in the middle, it asks for it states that documentation is required in support of a request. And this is basically an employee release. The employee would sign here, and by signing, the employee is authorizing their medical professional to release medical information in support of this request. Now, I briefly mentioned a healthcare professional form, which is another form that is required that the employee get completed. In concert with this form, which again is completed by the medical professional, an updated job description stating the essential functions of the job will be provided to the employee so that they may give this to their medical professional, making the medical professional fully equipped to answer the following questions. And the questions on this page are: does the employee have a mental or physical impairment that substantially limits a major life activity? If so, the medical professional is asked to describe the impairment and its impact on the individual's major life activity. When we say major life activity, that includes, but is not limited to, walking, seeing, hearing, speaking, breathing, learning, performing manual tasks, and caring for oneself. Another question, as you can see here, that's asked on this form is: does the impairment affect the employee's ability to perform one or more of the essential functions of the position? If so, they're asked to describe the impact on the person's ability to perform specific functions. And are there any workplace accommodations that you, the medical professional, believe would allow the employee to perform the essential functions of the job? And if so, they're asked to describe those accommodations. And another question is asked, and final question: is the need for an accommodation likely to be temporary or permanent? If temporary, how long do they anticipate or estimate the need for accommodation? Now, the steps to following in following the employee's request for an accommodation. Both the ADA request and the healthcare forms are reviewed by HR and legal to make a determination of the request. HR then meets with the division to determine if the request will cause an undue hardship. And after a decision has been made, HR and legal will meet with the employee and supervisor to discuss the accommodation. This entire discussion or process is known as the interactive process. Most, not all accommodations will have an end date. And if one is not provided by the doctor, one will be established by HR and legal. Sometimes employees will have a permanent injury. However, the employee is expected to perform the essential functions with or without an accommodation. One key takeaway for you is that this is an ongoing process, and even though an end date may not be provided, again, it's ongoing. Remember, each individual case differs from the next. Now, there are going to be times when a supervisor or manager may or even must ask an employee who has not requested an accommodation whether an accommodation is needed. A supervisor or manager should report the potential accommodation to HR. Then HR would then initiate the reasonable accommodation process, interactive process, without being asked if the employer, one, knows that the employee has a disability, knows or has reason to know that the employee is experiencing workplace problems because of the disability, and three, knows or have reason to know that the disability prevents the employee from requesting a reasonable accommodation. If the individual with a disability states that she or he does not need a reasonable accommodation, the employer will have been considered to have fulfilled its obligation. Now, you may ask yourself, how will I know as a supervisor or manager if someone needs an accommodation? There are no quote unquote special magic words needed for a qualified employee with a disability to request an accommodation. To request an accommodation, an individual may just use plain English and need not mention the ADA or use the phrase reasonable accommodation. For example, an employee tells her supervisor, I'm having trouble getting to work at my scheduled starting time because of medical treatments I'm undergoing. This is a request for a reasonable accommodation. Another example, an employee tells his supervisor, I need 6 weeks off to get treatment for a back problem. This is also a request for a reasonable accommodation. A new employee who uses a wheelchair informs the employer that her wheelchair cannot fit under the desk in her office. This is also a request for an accommodation. As this is obvious, that medical documentation is not necessary. Now, final example. An employee tells his supervisor that he would like a new chair because his present one is uncomfortable. Although this is a request for a change at work, his statement is insufficient to put the employer on notice that he is requesting reasonable accommodation. Basically, he does not link his need for a new chair with a medical condition. Now we want to take a look at your role as a supervisor or manager as it relates to the ADA process. You will need to ensure that the employee's essential functions are listed in their job description and announcement, and often in the interview questionnaire. As you're interviewing for a position, you should basically state what the requirements are for the position and also the essential functions of the position. At that point, the question can be asked, are you able to perform the essential functions of the job with or without an accommodation? And of course, document it on the questionnaire. Second, report possible accommodations to HR. Ask the employee, how can I help you? Never ask about an employee's medical condition, just what accommodation is needed. Act promptly, document all efforts, keep open lines of communication with the employee, comply with HR and legal's directive of the accommodation, and finally, notify HR if the employee is not in compliance with their accommodation. At that point, HR will reach back out to the employee to see if the accommodation is sufficient. We discussed earlier, use the term essential functions. What are essential functions? Essential functions are the basic job duties that an employee must be able to perform with or without reasonable accommodation. The supervisor must carefully examine each job to determine which functions or tasks are essential to the job performance. A job function is essential if the very existence of the job depends on the particular job function. And when a task is not fundamentally necessary to the performance of a particular job, it will be deemed as quote unquote non-essential function. Those identified as essential functions must be stated in the job description or job announcement. Now, earlier we touched on the interactive process. The interactive process basically is EEOC recommends that to determine effective accommodations, employers use what's called an interactive process, meaning that the employers and employees with disability who request accommodations work together to come up with accommodations. Now, one thing to make note of and to for any future requests is that courts often rule in favor of the party who tried to engage in this process and in good faith, and against the party who did not. Now let's look at some types of accommodation in work settings. As it physical modifications, making existing facilities accessible, or removing barriers that would make the facility accessible. Sign language interpreters and readers, assistive technology and modification of equipment or devices, job restructuring, modified work schedules and part-time work, redistributing marginal or non-essential work tasks, appropriate adjustments of exams, testing, training materials, or policies, telework, leave, reassignment of the employee to a vacant position, which is often the last resort. Now, let me just delve a little deeper in this last bullet point. As it relates to reassignment to a vacant position, the employer is not obligated to create a position. Questions are sometimes asked, and you may have or may in the future be asked this question: is this a confidential process? And yes, it is. And in order, even though there's an interactive process, is still confidential because we can talk about accommodations without disclosing specific medical conditions. So that's one thing that you can reassure an employee if the question is asked. Now we want to kind of touch on what is a satisfactory reasonable accommodation. Again, employers do not have to give the accommodation requested by the employee, but the accommodation must be equally effective, enable the employee to perform the essential functions of the job, enable applicants with a disability to have an equal opportunity to participate in the application process, and enable the employee to enjoy privileges and benefits of employment. Sometimes you may encounter a situation that more than one reasonable accommodation is effective. And if so, the preference of the individual with the disability should be given priority or primary consideration. Now, we just talked about satisfactory, reasonable accommodation. Let's take a look at some examples of what is considered unreasonable accommodation. These are accommodations that eliminates the essential function of the job, lowering production standards, providing personal use items such as prosthetic limbs, eyeglasses, hearing aids, wheelchair, placing an individual with a disability in a job for which he or she did not specifically apply. So that's definitely unreasonable accommodation. Placing an individual with a disability into a job if doing so would create a direct threat to the health and safety of others. Maintaining the salary of an employee reassigned from a higher paying job to a lower paying job if the employer does not do so for non-disabled individuals. We touched on earlier, creating a job. That's considered unreasonable. Violating a consistent, uniformly applied seniority system. Bumping another employee from his or her job. Changing to a new supervisor, medication monitoring, and improving leave when it's a critical position, or when the leave without pay is needed for an extremely long period of time. An undue hardship would be created if there are financial hardships, or the accommodation would be a significant disruption to the operations. Now let's take a look at undue hardship. Again, undue hardship is defined as a reasonable accommodation that are unduly extensive, substantial, or disruptive, or those that would fundamentally alter the nature or operation of the business. It has a very high threshold to meet. Cost in relation to the total financial resources of the entire agency is taken into consideration. And before denying an accommodation request because of undue hardship, employers are encouraged to explore different options that might make a seemingly difficult accommodation possible. Now, there are repercussions for the agency and possibly the supervisor for not following the ADA, the process, or ADA law. If DECAL does not follow the process, then the agency could face liability with financial consequences if the employee files a claim with the EEOC or GCEO, Georgia Commission on Equal Opportunity, or initiates a federal lawsuit against DECAL. As a supervisor, you could also be named as a defendant in the lawsuit for unlawful discrimination. In addition to financial consequences, the EEOC could request injunctive relief, which includes monitoring of the agency's practices and reviewing the agency's policies and procedures. Now, what are the repercussions? If the employer does not follow the process, they could lose their right to be provided a reasonable accommodation since they are refusing to participate in the process. And the same applies to an employee. They could definitely lose their right if they refuse to follow along in the process. Now, here we have some frequently asked questions. Number one, there are a total of 5 questions. Does an employee have to request an accommodation, or can management make a determination based on behaviors and/or performances? There are times when a manager or supervisor may or even must ask the employee who has not requested an accommodation whether the accommodation is needed. So the answer is yes. Does an employee have to complete the ADA request form? Yes, unless the disability is obvious. And does the employee's doctor have to complete the ADA medical form, or will the doctor's note stating the accommodation be sufficient? Yes, in the case that we discussed earlier, we had those scenarios where the employee in a wheelchair requested the height of the desk be raised, as this is obvious. A medical form is not necessary. Does an employee have to participate in the interactive process that is requested by HR? Yes. If they do not, then they are not in compliance with ADA law. What is the difference between FML and ADA? With FML, the employee is protected with job security while not working in the office due to an approved medical condition or disability. ADA, on the other hand, provides a path for maintaining one's employment in the office through an approved accommodation as long as all the essential functions of the job are met. Now, these are just 5 questions, frequently asked questions, but one thing I can tell you and one key takeaway from this presentation is that I'd like you to know the interactive process. We have that process, but also you as a supervisor and manager, if you have any questions whatsoever, please reach out to an HR representative and they either will be able to assist you or will guide you to the right person. You're not alone in this entire process. And again, if you have any questions, the best thing to do is to reach out to HR for some guidance. With that, I'd like to say thank you for joining me for this presentation. And if you have any questions, please reach out to HR. Have a good one.